BMG hired Rights Corp, which monitors BitTorrent activity to determine when infringers share its client's copyrighted work. When Rights Corp identifies such sharing, it emails an infringement notice to the alleged infringer's ISP. Another email summarized Cox's practice more succinctly: DMCA equals reactivate. The jury found Cox liable and awarded BMG $25 million in statutory damages. The United States Court of Appeals for the Fourth Circuit. BMG Rights Management and Roundhill Music versus Cox Communications, and party in interest down here is Rights Corp. You may remember Rights Corp from such lawsuits as, did you copy our article or movie or music or whatever on BitTorrent or on your website, and we're going to come after you. Rights Corp's behind a lot of anti-piracy lawsuits, let's put them that way. Diana Gribben-Motz, Circuit Judge, Fourth Circuit, writes, BMG owns copyrights in musical compositions and filed this suit alleging copyright infringement against Cox Communications, provider of high-speed internet access. BMG seeks to hold Cox contributorily liable for infringement of BMG's copyrights by subscribers to Cox's internet service. Following extensive discovery, the district court held that Cox had not produced evidence that it had implemented a policy entitling it to a statutory safe harbor defense, and so granted summary judgment on that issue to BMG. After a 2-week trial, a jury found Cox liable for willful copyright infringement and awarded BMG $25 million in statutory damages. Cox appeals, asserting that the district court erred in denying it a safe harbor defense and incorrectly instructed the jury. We hold that Cox is not entitled to the safe harbor defense and affirm the district court's denial of it. But we reverse in part, vacate in part, and remand for a new trial because of certain errors in the jury instructions. Cox is a conduit, internet service provider providing approximately 4.5 million subscribers with high-speed internet access. Some of Cox's subscribers shared and received copyrighted files, including music files, using a technology known as BitTorrent. BitTorrent is not a software program, but rather describes a protocol, a set of rules governing the communications between computers that allows individual computers on the internet to transfer files directly to other computers. This method of file sharing is commonly known as peer-to-peer file sharing and contrasts with the traditional method of downloading a file from a central server using a web browser. Although peer-to-peer file sharing is not new, what makes BitTorrent unique is it allows a user to download a file from multiple peers at the same time, even peers who only have a piece of the file rather than the complete file. In other words, as soon as a user has downloaded a piece of a file, he or she can begin sharing that piece with others while continuing to download. This innovation makes sharing via BitTorrent particularly fast and efficient. Although BitTorrent can be used to share any type of digital file, many use it to share copyrighted music and video files without authorization. As an ISP, Cox only provides internet access to its subscribers. Cox does not create or sell software that operates or uses the BitTorrent protocol, storing copyright information on its own computer servers or controlling what its subscribers store on their personal computers. Cox's agreement with its subscribers reserves the right to suspend or terminate subscribers who uses Cox's service to post, copy, transmit, or disseminate any content that infringes the patents, copyrights, or proprietary rights of any party. To enforce that agreement and protect itself from liability, however, Cox created only a very limited automated system to process notifications of alleged infringement received from copyright owners. Cox's automated system rests on a 13-strike policy that determines the action to be taken based on how many notices Cox has previously received regarding infringement by a particular subscriber. The first notice alleging a subscriber's infringement produces no action from Cox. The 2nd through 7th results in a warning email. The 8th and 9th limits the subscriber's internet access to a single web page that contains a single warning, but the subscriber can reactivate by clicking an acknowledgement. After the 10th and 11th, Cox suspends services, requiring the subscriber to call a technician who explains the reason for suspension and advises removal of infringement and reactivates service. After the 12th, the subscriber is suspended and directed to a specialist who issues another warning to cease infringement, then reactivates service. After the 13th, the subscriber is again suspended, and for the first time considered for termination. Cox never actually terminates a subscriber. The effectiveness of Cox's 13-strike policy as a deterrent has several additional limitations. Cox restricts the number of notices it will process from any copyright holder or agent in one day. Any notice received after this limit has been met does not count. Cox only counts one notice per subscriber per day, and Cox resets a subscriber's 13-strike counter every 6 months. BMG, a music publishing company, owns copyrights in musical compositions. To protect this copyrighted material, BMG hired Rights Corp, which monitors BitTorrent activity to determine when infringers share its client's copyrighted work. When Rights Corp identifies such sharing, it emails an infringement notice to the alleged infringer's ISP. The notice contains the name of the copyright owner, the title of the copyrighted work, the alleged infringer's IP address, a timestamp, and a statement under penalty of perjury that Rights Corp is the authorized agent and the notice is accurate. Rights Corp also asks the ISP to forward the notice to the alleged infringing subscriber. This is what we call the DMCA letters. This is not actually a requirement of law, so they only ask the ISP to forward the notice, since only the ISP can match the IP address to the subscriber's identity. For that purpose, the notice contains a settlement offer, allowing the alleged infringer to pay $20 or $30 for a release from liability for the instance of infringement alleged in the notice. Cox has determined to refuse to forward or process notices that contain such settlement language. When Cox began receiving Rights Corp notices in the spring of 2011, Cox notified Rights Corp that it would only process the notices if Rights Corp removed the settlement language. Rights Corp did not do so. Cox never considered removing the settlement language itself or using other means to inform its subscribers of the allegedly infringing activity observed by Rights Corp. Rights Corp continued to send Cox large numbers of settlement notices. In the fall of 2011, Cox decided to blacklist Rights Corp, meaning Cox would delete notices received from Rights Corp without acting on them or even viewing them. BMG hired Rights Corp in December 2011 after Cox blacklisted Rights Corp. Thus, Cox did not ever view a single one of the millions of notices that Rights Corp sent to Cox on BMG's behalf. On November 26, 2014, BMG initiated this action against Cox. BMG alleged that Cox was vicariously and contributorily liable for the acts of copyright infringement by its subscribers. At the conclusion of discovery, the parties filed multiple-issue cross motions for summary judgment, which was resolved in a very carefully written opinion. Among these issues, BMG asserted that Cox had not established a policy entitling it to the safe harbor defense contained in the Digital Millennium Copyright Act. To qualify for that safe harbor, an ISP like Cox must have adopted and reasonably implemented a policy that provides for the termination in appropriate circumstances of subscribers who are repeat infringers. The district court agreed with BMG and held that no reasonable jury could find that Cox implemented a policy that entitled it to that DMCA safe harbor. The court explained that BMG had offered evidence that Cox's new accounts were being used repeatedly for infringing activity, yet failed to terminate those accounts, and that Cox did not come forward with any evidence to the contrary. Accordingly, the court granted summary judgment to BMG on Cox's safe harbor defense. The case proceeded to a jury trial that involved the testimony of more than a dozen witnesses and admission of numerous documents. At the conclusion of the trial, the district court instructed the jury that to prove contributory infringement, BMG had to show direct infringement, that Cox knew or should have known of such activity, and that Cox induced or caused or materially contributed to such activity. The court further instructed the jury that BMG could prove Cox's knowledge by showing willful blindness if Cox was aware of the high probability that Cox users were infringing, but was consciously avoiding confirming the fact. The jury found Cox liable and awarded BMG $25 million in statutory damages. The jury also found that Cox was not liable for vicarious infringement. The district court denied all post-trial motions and entered judgment in accordance with the verdicts. Cox appeals, arguing that BMG should not have been granted summary judgment as to the DMCA safe harbor and that the erroneous jury instructions entitle it to a new trial. Really interesting stuff. We're not going to stop there, but I do want to talk at you for a moment. Yours truly has defended people from these DMCA letters. What usually happens is as they said, the rights holder or authorized representative sends a DMCA sort of takedown notice. It's a notice to the ISP that they've discovered infringement on the ISP's network, and they'd like the ISP to take appropriate action to prevent it. But they also separately ask the ISP to forward that letter to the individual subscriber, and then they include additional text for the subscriber, like to the subscriber, like, "Dear subscriber, we see that you've infringed on 45 of our songs, or 25 of our music videos, or 35 of our adult entertainment titles." And they offer an amount. The amount can vary, and they offer to allow you to go to a website and type in a identifier, a username and password that they've provided in the letter, a unique identifier, and then that in turn pops up a message of how much infringement you're accused of and what the price is to make it go away. Cox doesn't want to forward those notices, and has taken a hard stance on whether they have to forward the whole notice, part of the notice, or whatever. And it appears that what they've done is not forwarded the notices at all since about 2011, which was about when this started. And just so you're aware of the coincidence here, when was it that yours truly graduated from law school and got his license? 2011. So when I got started doing these BitTorrent cases was basically when they started doing these BitTorrent cases. And it's been quite a ride. I've represented over 600 defendants in these kinds of BitTorrent file sharing cases. So this really hits close to home. Now, the rest of this opinion is going to be dealing with Cox's appeal, and we're going to find out why the Fourth Circuit sent the case back for a new trial while still affirming that Cox is guilty of not maintaining its safe harbor by maintaining its disconnect practices. We first address Cox's contention that the district court erred by denying it a safe harbor defense. We'll review brand new. The DMCA provides a series of safe harbors that limit copyright infringement liability of an ISP and related entity. As a conduit ISP, Cox seeks the benefit of a safe harbor contained in Section 512A. To fall within that safe harbor, Cox must show that it meets the threshold requirement common to all Section 512 safe harbors, that it has adopted and reasonably implemented a policy that provides for the termination in appropriate circumstances of subscribers who are repeat infringers. Cox's principal contention is that repeat infringers means adjudicated repeat infringers, people who have been held liable by a court for multiple instances of copyright infringement. Cox asserts that it has complied with the requirement and is therefore entitled to the safe harbor defense. BMG responds that Cox's interpretation of repeat infringers is contrary to the DMCA's plain terms. Because the statute does not define the term repeat infringers to resolve the question, we first turn to the term's ordinary meaning. The ordinary meaning of an infringer is someone who interferes with the exclusive rights of a copyright holder. A repeat infringer is thus one who infringes a copyright more than once. Cox contends that because the repeat infringer provision uses the term infringer without modifiers such as alleged or claimed that appear elsewhere in the DMCA, infringer means adjudicated infringer. But the DMCA's use of phrases like alleged infringer in other parts of the statute only indicates the term infringer alone must be something different from an alleged infringer. Otherwise, the word alleged would be superfluous. Using the ordinary meaning of infringer, however, would fully accord with this principle. Someone who actually infringes a copyright differs from someone who has merely alleged infringement of a copyright because an allegation could be false. The need to differentiate the terms infringer and alleged infringer thus does not mandate Cox's proposed definition. Moreover, other provisions of the Copyright Act use the term infringer to refer to all who engage in infringing activity, not just the narrowest subset of those who have been so adjudicated by a court. For example, Section 501A creates a civil cause of action for copyright owners, states that anyone who violates any of the exclusive rights of a copyright owner provided for in the statute is an infringer of the copyright or right of the author. Similarly, the DMCA itself provides that ISPs who store copyrighted materials are generally not liable for removing material or activity claimed to be infringing or based on facts or circumstances from which infringing activity is apparent, regardless of whether the material is ultimately determined to be infringing. This provision expressly distinguishes among three categories of activity: actively merely claiming to be infringing, actual infringing activity, as is apparent from facts or circumstances, and activity ultimately determined to be infringing. This distinction between infringing activity and activity ultimately determined to be infringing shelters ISPs from being liable for taking down material that is infringing, even if no court ultimately determines that it is infringing, because, for example, the copyright holder simply does not file a lawsuit against the person who uploaded the infringing material. As this provision illustrates, Congress knew how to expressly refer to adjudicated infringement, but did not do so in the repeat infringer provision. This suggests that the term infringer in Section 512 is not limited to adjudicated infringers. They will look into the legislative history, they will look into other circuits considering the definition, and then they reject it. And for time purposes, we're going to skip those sections. Section 512I thus requires that to obtain the benefit of a DMCA safe harbor, Cox must have implemented a policy that provides for the termination in appropriate circumstances of its subscribers who repeatedly infringe copyrights. We are mindful of the need to afford ISPs flexibility in crafting policies and the difficulty in determining what is appropriate and when it is appropriate to determine the access to a person's internet. At a minimum, it must be reasonably implemented. Carrying out its 13-strike process, Cox has very clearly determined not to terminate subscribers who, in fact, repeatedly violated the policy. The words of Cox's own employees confirm this conclusion. In a 2009 email, the executive management of Abuse Group, a team tasked with addressing subscribers' violations of Cox's policy, explained to his team that if a customer is terminated for DMCA, you are able to reactivate them. After you reactivate them, the DMCA counter restarts. This is to be an unwritten semi-policy. If it is for the DMCA, you can go ahead and reactivate. Once the customer has been terminated, we have fulfilled the obligation of the DMCA safe harbor and can start over. He elaborated this would allow Cox to collect a few extra weeks of payments for their accounts. Winky face. Another email summarized Cox's practice more succinctly: DMCA equals reactivate. As a result of this practice, from the beginning of the litigated time period until September 2012, Cox never terminated a subscriber for infringement without reactivating them. Cox nonetheless contends that it lacked actual knowledge of its subscribers' infringement and therefore did not have to terminate them. That argument misses the mark. The evidence shows that Cox always reactivated subscribers after termination, regardless of its knowledge of the subscriber's infringement. Cox did not, for example, advise employees not to reactivate a subscriber if the employees had reliable information regarding the subscriber's repeat infringement. An ISP cannot claim the protections of the DMCA safe harbor provisions merely by terminating customers as a symbolic gesture before indiscriminately reactivating them within a short time frame. In September 2012, Cox abandoned its practice of routine reactivation. An internal email advised new customer service representatives that we now terminate for real. BMG argues this was a change in form rather than substance because instead of terminating and then reactivating, Cox simply stopped terminating them in the first place. The record supports this view. Before September 2012, Cox was terminating and reactivating 15.5 subscribers per month on average. After September 2012, Cox abruptly began terminating less than 1 subscriber per month on average. From September 2012 until the end of October 2014, the month before BMG filed suit, Cox issued only 21 terminations. Of those 21, at least 17 terminations concerned subscribers who had either failed to pay their bills on time or had used excessive bandwidth. Cox did not provide evidence for the remaining 4 terminations that were for repeat copyright infringement. But even assuming they were, they stand in stark contrast to the over 500,000 email warnings and temporary suspensions Cox issued to alleged infringers during the same period. Moreover, Cox dispensed with terminating subscribers who repeatedly infringed BMG's copyrights, in particular when it decided to delete automatically all infringement notices received from BMG's agent Rights Corp. As a result, Cox received none of the millions of infringement notices that Rights Corp sent on BMG's behalf. Although our inquiry concerns Cox's policy towards all of its repeating infringing subscribers, not just those who infringed BMG's copyrights, Cox's decision to categorically disregard all notices from Rights Corp provides further evidence that Cox did not reasonably implement a repeat infringer policy. Cox responds that these post-September 2012 emails do not necessarily prove actual knowledge of repeat infringement. Again, that argument is misplaced. Cox bears the burden of proof on the DMCA safe harbor defense, thus Cox had to point to evidence showing that it reasonably implemented a repeat infringer policy. The emails show that Cox internally concluded that a subscriber should be terminated after the next strike, but then declined to do so because it did not want to lose revenue. In addition, Cox suggests that because the DMCA merely requires termination of repeat infringers in appropriate circumstances, Cox decided not to terminate certain subscribers only when appropriate circumstances were lacking. But again, Cox failed to provide evidence of the determination of appropriate circumstances, and that it played any role in its decisions to terminate or not terminate. We turn to Cox's other principal challenge, that the district court erred in instructing the jury as to contributory infringement. We review a trial court's jury instructions for abuse of discretion. We review de novo whether the instructions correctly state the law. Cox's initial jury instruction argument rests on its contention that it cannot be held liable for contributory infringement because its technology is capable of substantial non-infringing use. According to Cox, the district court erred in refusing to instruct the jury on this principle, but that argument is meritless. Of course, the mere sale of a product that has both lawful and unlawful uses does not in and of itself establish an intent to infringe. That is the holding of Sony Corp of America versus Universal City Studios. In Sony, copyright holders sought to hold Sony contributory liable for selling video cassette recorders that customers use to tape copyrighted programs. The Supreme Court rejected that claim, holding that because a VCR was capable of commercially significant non-infringing uses, its manufacturer, Sony, could not be held contributory liable for the distribution of the VCR. A few courts initially interpreted Sony's limitation, as Cox does, to mean that if a product can be substantially used lawfully, its producer cannot be contributory liable for copyright infringement. But in Grokster, the Supreme Court rejected that broad reading. The court clarified that Sony barred secondary liability based on presuming or imputing intent to cause infringement. The Grokster court explained that under Sony, intent to infringe will not be presumed from the equivocal conduct of selling an item with substantial lawful as well as unlawful uses, even when the seller has the understanding that some products will be misused. More is needed. But the fact that a product is capable does not mean that the producer can never be held liable. Since the same flaw infects Cox's related argument that the district court erred in refusing to instruct the jury that it is not a material contribution to provide a product, as the Supreme Court explained, reversal was required in Grokster because the Ninth Circuit has read Sony's limitation to mean that whenever a product is capable of substantial lawful use, the producer can never be contributory liable. This was not the view of Sony, however, said Grokster. Because the instruction Cox requested misstates the law, the district court did not err in refusing to give it. In fact, providing a product with substantial non-infringing uses can constitute a material contribution for copyright infringement. See Perfect 10 versus Amazon. Grokster makes clear that what matters is not simply whether the product has some or even many non-infringing uses, but whether the product is distributed with the intent to cause copyright infringement. Thus, contrary to Cox's argument, the fact that its technology can be substantially employed for a non-infringing use does not immunize it from liability. Next, Cox contends on contributory infringement that the court erred in charging the jury as to the intent necessary. Specifically, Cox challenges a district court's instruction that the infringement could be found if the jury found Cox knew or should have known of such infringing activity. We agree in so instructing the jury that the court erred. Grokster teaches that one infringes contributorily by intentionally inducing or encouraging direct infringement. The requisite intent, however, may be presumed according to the rules of fault-based liability derived from the common law. The most relevant of these common law rules is that if a person knows that the consequences are certain, or substantially certain to result from his act, and still goes ahead, he is treated by law as if he had in fact desired to produce the result. Under this principle, when an article is good for nothing else but infringement, there is no injustice in presuming or imputing an intent to infringe based on its sale. Assuming the seller is aware of the nature of his product, that its only use is infringing, he knows that infringement is substantially certain to result. He may therefore be presumed to have intended the result. A similar result follows when a person sells a product that has lawful uses, but with the knowledge that a buyer will in fact use the product to produce infringing results. In that circumstance, the seller knows the infringement is substantially certain to result from the sale. Consequently, the seller causes the infringement, intends to cause the infringement just as much as the seller who provides a product that has exclusively unlawful uses. See Henry v. A.B. Dick Company. In Henry, a 100-year-old Supreme Court case involving contributory patent infringement that the Supreme Court cited in Grokster rests on this very reasoning. There, the court affirmed a judgment for contributory infringement based on the defendant's sale to a specific person with knowledge that the products would be used to infringe, even though the product, ink, also had non-infringing uses. The court reasoned that because defendants sold the ink with the expectation that it would be used to infringe, the purpose and intent that it would be so used could be presumed. These principles apply equally in cases like this one that involve subscription services or rentals rather than one-time sales. Consider a company that leases VCRs, learns that specific customers use their VCRs to infringe, but nonetheless renews the lease to those infringing customers. Given those facts, the company knows that its action, renewing the lease of the VCR to these specific customers, is substantially certain to result in infringement, and so an intent to cause infringement may be presumed. It is well established that one mental state slightly less demanding than actual knowledge, willful blindness, can establish the requisite intent for contributory copyright infringement. This is so because the law recognizes willful blindness as equivalent to actual knowledge. Whether other mental states, such as negligence, where a defendant should have known, can suffice to prove contributory copyright infringement presents a more difficult question. The parties refer to this as the should-have-known or constructive knowledge standard. We follow the Supreme Court and refer to it as the negligence standard. This notion that contributory liability can be imposed based on something less than actual knowledge or its equivalent, willful blindness, is not entirely without support. Nonetheless, we believe for several reasons that, as Cox contends, negligence does not suffice to prove contributory infringement. Rather, willful blindness is required. First, Grokster's recitation of the standard that one infringes contributorily by intentionally inducing or encouraging direct infringement is, on its face, difficult to reconcile with a negligence standard. In addition, it would have been unnecessary for the court to discuss in detail the situations in which intent may be presumed, and those situations, like Sony, in which it may not, if liability did not require intent at all, but merely required negligence. Looking to patent law, as the Supreme Court did in Sony and Grokster, further counsels against a negligence standard. The Supreme Court has long held that contributory patent infringement requires knowledge of at least direct infringement. In 2011, the court held that willful blindness satisfies this requirement, but reckless and negligence do not. The court reaffirmed this holding in 2015, stating that contributory patent infringement requires proof the defendant knew the acts were infringing, and that Global Tech, the case, was clear in rejecting any lesser mental state as the standard. The court expressly rejected the possibility that a person or entity could be liable even though he did not know the acts were infringing. Thus, in the patent context, it is clear that contributory infringement cannot be based on a finding that defendant should have known of infringement. We therefore hold that proving contributory infringement requires proof of at least willful blindness. Negligence is not sufficient. In sum, the district court erred in charging the jury that Cox could be found liable for contributory infringement if it knew or should have known of such infringing activity. The formulation should have known reflects negligence and is therefore too low a standard. And because there is a reasonable probability that this erroneous instruction affected the jury's verdict, we remand for a new trial. Although we have concluded that the district court incorrectly instructed the jury in some instances, we reject Cox's argument that with proper instructions it's entitled to judgment as a matter of law. For the reasons stated above, we affirm the District Court's grant of summary judgment to BMG on the Section 512A DMCA safe harbor defense, but reverse and remand for a new trial. We also vacate the District Court's grant of attorney's fees and costs to BMG and its denial of fees and costs to Cox. Affirmed in part, reversed in part, vacated in part, and remanded. That is BMG Rights Management and Roundhill versus Cox Communication, with Rights Corp thrown in as BMG's agent and representative for the DMCA notices. Whew! What do you think of that? Holy mackerel. 13 strikes? Cox lets you get up to 13 strikes before even considering terminating your account, and they didn't even terminate people after that, or they would terminate them and then immediately reinstate them. What kind of BS is that?
Jeez.
Wow. Here's my stress ball that I use to de-stress when I'm feeling stressed out. Raw. How are you? How are you, my Nico? Huh? Is it Nico time already?
Well,
Is it Nico time already?
we're definitely making up for the missed dogs and all the streams over the past couple of weeks.
Is it Nico time already? Is it Nico time already? Oh, he's so good. He's so good boy. He's so good boy. I love this dog. He's so good boy.